We are deeply concerned that the National Treasury has proceeded to complete the sale of the government's 15% stake in Safaricom PLC to Vodacom, while our substantive constitutional petition remains pending before the High Court. This transaction has been closed under a cloud of unresolved constitutional questions. The High Court had, on two separate occasions, found sufficient basis to issue conservatory orders stopping the sale until the constitutional petition was heard and determined. That petition has already been heard, and the High Court is expected to pronounce itself within the next 2 weeks. So one would wonder why rush the conclusion of the sale when in 2 weeks the High Court will be issuing their ruling. It is therefore deeply the government moved with such speed to dispose of the very asset that is the subject of the pending constitutional proceedings. And I need to note here that that matter of lifting the orders was initially set for the 29th, but the Registrar of the Court of Appeal, of course in collusion with others, decided to bring it to the 18th of June. We respect the courts, of course, some of us are officers of the courts, but Kenyans are entitled to ask if a matter is still pending before the High Court, and if the asset in dispute can be transferred before the hearing, what protection does constitutional litigation truly offer the ordinary citizen? Let us be clear, the Court of Appeal did not declare this transaction lawful. It did not determine whether Kenyans were properly consulted. It did not determine whether Safaricom was fairly valued. It did not determine whether the government can lawfully sell a strategic national asset merely to raise short-term revenue. The Court of Appeal only dealt with the question of conservatory orders. The government has not been allowed to outrun the court process. The due process of the law ought to have been allowed to take into account its to take its course to its proper legal conclusion. This is a matter of great public interest because public wealth belongs to the people of Kenya, not to temporary office holders like the Treasury mandarins. And I saw the comments by the Cabinet Secretary for the Treasury before JK Live. It's of a big shame, private interests, or indeed foreign corporations. This is not an ordinary share sale. Safaricom is not just another company. It is the backbone of Kenya's digital economy. M-Pesa moves trillions of shillings every year. Safaricom's infrastructure supports payments, communications, businesses, public services, sensitive data, and the daily lives of millions of Kenyans. Kenyans are therefore entitled to ask a simple question: why was the government in such a hurry to sell a highly profitable and strategic national asset before the High Court could pronounce itself? The government has sold approximately 6 billion shares at the valuation, according to them, of 34 shillings per share, reducing its ownership from 35% to 20% and giving Vodacom effective majority control at about 55%. We maintain that this sale was undervalued, was opaque, was rushed, and constitutionally suspect. Expert evidence placed before the court indicated that the fair value of the shares was at the very least approximately Kenya shillings 57.90 per share, just under 58 shillings. If M-Pesa is properly valued and as a standalone fintech platform, the public value potentially lost runs into hundreds of billions of shillings. That is not a minor pricing dispute. It is a matter of our national wealth, public accountability, and the safeguarding of Kenya's strategic